Hello, this is Matt on the Moon Family Sedan channel. I've got two topics to share with you in this latest room temperature jam. I'll be starting with this one from the Crypto Basic. Deaton explains why Ripple will want to settle even if it wins big against SEC. And so I'll note here, even at the outset of the video, regarding the SEC v. Ripple case, settlement can occur before or after a ruling from Judge Torres on summary judgment. Now, after a decision from Judge Torres, Ripple can settle with the SEC regardless of whether they win or lose. And this isn't something that I think I fully understood until really recently, to be honest with you. It just hadn't been articulated, certainly not to this degree. So even if Ripple wins, they could still settle with the SEC even after Judge Torres's summary judgment issuance, whenever that comes out. And then there's also this. And this is an article written by attorney John Deaton, which was published today. It's on Bloomberg, and it's also on his crypto law website. But here's the version that's on Bloomberg. I mean, it's the same thing. I'm just noting that it's published here. And John Deaton titled this, SEC Crypto Litigation Ventures into Dangerous Legal Territory. Now, this article by John Deaton, I have not read yet, so I thought we could just experience it together for the first time here on the Moon Family Sedan channel. Because look, when it comes to attorney John Deaton, I know I'm going to cover it. I don't need to vet this stuff. It's John Deaton, folks. So anyway, I thought it'd be fun for us to experience that together. But before going any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Just a small bit of table setting here to make sure that we are all on the same page. I made a video just last night, actually, a video I wasn't planning on recording because there are just wild rumors yesterday and a little bit today, but mostly yesterday, circulating that there would be some sort of meeting between Ripple and the SEC on May 8th. And so obviously you know that means potentially settlement should it happen, but it's completely unsubstantiated. And I saw so many people talking about it, I was like, okay, I got to say my piece on this. So I did last night. Part of what I shared is what's on your screen, and I'm not going to go through literally everything I covered in that video. That thing's probably like almost 14, 15 minutes. This is the only part that I really want to make sure that you are aware of, just these few tweets from John Deaton on the screen for those of you that may have missed this. And then I'm going to get to the very latest stuff from it because it builds from this. That's the reason that I need to cover this and go back just a little bit here. But to be clear, yeah, the May 8th thing, that's just, it's completely unsubstantiated nonsense, bunk. It ain't happening. It just ain't happening. And so on that topic, attorney Deaton wrote, this is not how a settlement happens. First, I believe the only time a settlement occurs in this case is after a ruling by Judge Torres, and that happens only if Ripple gets a big victory so Gensler could save face and get a political win via settlement. Sorry, not going to happen. And so I'll pause to note, that's the reason I'm setting the table with this, because that's where attorney John Deaton stated that if settlement occurs, it's only going to be after a ruling by Judge Torres. And I think that caught a lot of people off guard. And admittedly, until recently, I didn't understand that that's something that could potentially occur. Like, would that be the technical term to apply to it? And that's what I'm getting at right here. In fact, I think most of us didn't know that, you know, after a conclusion, regarding like a decision on something for like summary judgment, if a defendant loses, I think most of us, not in the legal world, didn't understand that the proper term for what occurs after that is settlement. Typically, that's what would happen. You work on settlement. And that's what happened in the library case, for example, because obviously library lost, but then there's still settlement terms afterwards. So anyway, and then attorney Deaton also wrote, how is Gensler going to agree that ongoing and future sales of XRP are not securities and pursue Coinbase and others? Sure, he could try and thread the needle and somehow claim that XRP is like no other token after claiming that it was like others for over 2 years. Second, because of claims of market manipulation and insider trading, they wouldn't set a meeting and run the risk of a leak and influence the market. They would just meet and then come to terms. If they could, and then and only then would they report a settlement to the judge. This unconfirmed source sounds like someone was wanting to orchestrate a pump. And so that's what he said yesterday, and that's the part that I covered. Now, some of the latest stuff, update on this, though, has to do with, okay, so what would this even look like and why? So somebody from our community named Jess wrote to John Deaton on that topic from the tweet, the short thread I just shared with you, and wrote, "I have a stupid question. Why would Ripple want to settle if they win big? I will tell Gary to hop a husky." I am not familiar with that term. And then Attorney John Deaton retweeted that, and he wrote the following to clarify. He said, "Quite a few people ask, why would Ripple settle if they won? First, I didn't say Ripple would agree to the same terms of a settlement they would have agreed to 2 years ago. It all depends on the ruling itself. Does Coinbase and Kraken immediately relist or wait for an appeal? Does Bank of America, a Ripple partner, feel comfortable with the decision or wait to see if Judge Torres gets overturned if the SEC appeals her ruling? Remember, the SEC can file a notice of appeal and withdraw it later. If the SEC told Ripple it would issue a statement that all future sales of XRP are not securities, and not saying it would, and not appeal if Ripple agrees to pay $50 million, I believe the certainty and immediate return of liquidity to the United States makes Brad Garlinghouse write a check in seconds. If Judge Torres' decision is in Ripple's favor and it facilitates liquidity to return to the U.S. and it causes U.S. businesses to not worry about pissing off the SEC if they use XRP, then that's a different story." And so, folks, you can see what he's getting at here. Attorney John Deaton is saying it depends on to what degree there might be clarity for transactions in the United States, regardless of whether or not Ripple technically had any infractions based on transactions up to the point of the lawsuit. So that's the question. Now, that's why there's a little bit of flexibility. So maybe, the SEC might, in theory, be able to save some face, even if the summary judgment from Torres ends up being more favorable towards Ripple. What John Deaton is saying here, and this is something I didn't realize until he shared this, is that there could be incentive for Brad Garlinghouse to still write some sort of big ass check for the SEC if it provides additional clarity. Now, would the SEC do that? And again, well, that's the question. And Deaton here is not saying that they would, but he's just kind of walking you through the thought process here of what might potentially lead to such an outcome. And now on to this article, which we get to experience for the first time together. And again, it's on Bloomberg here, written by Attorney John Deaton. He titled it, SEC Crypto Litigation Ventures into Dangerous Legal Territory, and it was published for the first time just this morning, and it reads as follows. The U.S. Supreme Court issued the landmark SEC v. Howey decision in 1946, laying out a specific definition of what constitutes a security. Those justices couldn't have guessed how complex digital commerce over encrypted lines of computer code would fit in almost a century later. The Securities and Exchange Commission under Chairman Gary Gensler has its own idea of how cryptocurrencies should be regulated today, but bears little resemblance to that decision, and it's straying into dangerous legal territory in court. The Howey case involved orange groves sold by a Florida resort to tourists in a scheme where the investors earned passive income from the resort's management and commercialization of the oranges. The so-called Howey test says a transaction is a security if it is an investment of money in a common enterprise with a reasonable expectation of profit derived from the efforts of others. All three prongs of the test must be met. Hundreds of federal cases that followed found unregistered securities in the packaging and sales of whiskey, condos, chinchillas, oil and gas, and beavers. I just got to pause here. Now, Attorney John Deaton, you know that the beaver itself is the security, right? In chinchillas, the nature of the chinchilla is that of a security. It's not just that it was in a scheme, right? It's that the chinchilla and the beaver itself, these living creatures, those are the definition of securities, right? Well, that's effectively what Kim Jong-Gensler and the rest of the clowns over at the SEC would have you believe when it comes to XRP itself, so why the hell not? Attorney Deaton then writes, a scheme to sell any asset, including cryptocurrencies, could easily fit into this test. A modern securities law is built on it. But this isn't what the SEC has been arguing for 2 years in the biggest unregistered securities enforcement action to date against a crypto company. The suit was filed against U.S. software company Ripple Labs, which sells a digital payment solution for banks and includes cryptocurrency XRP as a bridge asset to settle cross-border payments in seconds for almost no cost. Since 2013, the company has also sold billions of XRP tokens it holds to various crypto exchanges who resold them on the secondary markets to millions of retail holders. Over the last decade, the XRP ledger grew as a decentralized, permissionless, distributed ledger with a variety of uses by other companies and individuals. The XRP token eventually rose to having the third highest market cap for any cryptocurrency in the world. Yeah, and I just pause to point out one thing, because this is one of the most obvious holes when it comes to regulatory certainty, or, well, I mean, lack thereof. When you're talking about a decentralized, permissionless network, such as the XRP ledger, we're talking about distributed ledger technology, this is where the question of what constitutes a common enterprise as it pertains to this comes into play. Because if a network starts out as centralized, I mean, it'd be pretty easy to argue. Oh, okay, well, there you go. If there's an entity and this is it, and it's a closed network, let's say it's literally a centralized network, and there's a token on it. If you're selling that, well, that would be much easier to satisfy the Howey test. Very clear, right? Especially when it comes to the common enterprise part. But where the SEC refuses to provide clarity, it's on this question of, well, okay, but what happens when a network does shift to become more decentralized? What's that mean for additional participants? And that's why what they should recognize is that, this is the truth, and Attorney Deaton has talked about this ad nauseum, you focus on specific transactions for specific market participants. And so as a network continues to decentralize, if you want to go additionally after, maybe participants that had nothing to do with the creation of it, which could happen, by the way, you could do that, but you'd have to focus again on those specific, those specific individuals for those specific transactions. But there's a very notable lack of clarity here as it pertains to, okay, but what constitutes such? And so it's very easy to understand. And that's why I say, it's not necessarily that, this is my personal opinion, it's not necessarily that you'd have to throw out, the entirety of the Howey test and securities law. I'm not necessarily pushing for that. I think with certain revisions that are well thought out, you could probably fix this thing and it probably would work. If you can take care of something like that, it seems, in my estimation, having followed this for over 2 years, that you'd be most of the way there. So we'll see if something like that. And of course, now there are separate considerations when it comes to other aspects of, DeFi and what's it mean for cryptocurrency exchanges. But specifically when it comes to, tokens themselves and people building, developers building on top of the ledger, that's just the way that I personally look at it. Anyway, Attorney Deaton continues, though. Make sure I get the right spot here. There we go. Oh, that was I don't know if you guys heard that cough. That's my dog under the desk. What are you chewing? Hey, what are you doing? Hold on. What are you doing? She's trying to chew. What are you trying to chew on? There's no toy under there. All there is a cord. I'm sorry, folks. She's got a little bit of an upset tummy here. Come here. Peep, come here. Can you just lay down? Come here. It's okay. It's okay. For the new dog owners, you're gonna get it. She was. I took her on a walk earlier. And then she started chewing on grass, and as soon as that happened, you know what that means if you're a dog owner. That means that the dog probably has an upset tummy. So here we have nothing under the desk, and she's almost always under my desk when I'm recording videos. And she started chewing. I'm like, there's nothing to chew. And it looked like she was almost trying to get at a cord or something. I'm not sure. I don't think she got. I'm sorry. Anyway, my apologies for that. Let me go forward here. It's okay. Come here. It's okay. Here, I'm gonna pick you up. Come here, sweetie. Okay, I got you. All right. Ooh, all right. Let's proceed here. I'm so sorry, folks. Anyway, over the last decade, the XRP ledger grew as a decentralized, permissionless, distributed ledger with a variety... Okay, this isn't going to work either because you're making dog sounds. All right, just... Pete, I ain't going to put you back. You've got to be quiet. Pete. All right. Can you lay down? Can you lay down? Pete, lay down. Come on, sweetie. Okay, you just stay there. Okay, good girl. Sincere apologies. Over the last decade, the XRP ledger grew as a decentralized, permissionless, distributed ledger with a variety of uses by other companies and individuals. The XRP token eventually rose to having the third highest market cap for any cryptocurrency in the world. I am an XRP holder and trial lawyer, so I read the SEC's complaint as soon as I heard about it. I expected to see the SEC pointing to a scheme of specific early sales by Ripple of XRP, which met the Howey test. That would have made sense. But I was shocked to read that the SEC was arguing that all sales of XRP have always been and would always be securities because the very nature of the digital asset is to be a security and nothing else. You're right, John, but come on, that's just like beavers and chinchillas, right? I kid, of course. Anyway, Attorney Deaton then says, the token itself is the embodiment of an investment contract in Ripple, they argue, even on the secondary markets with no involvement of the company, including mine. This goes beyond anything the 1933 Securities Act and over 250 federal appellate and Supreme Court decisions about securities law ever imagined. The SEC's argument is the equivalent of the oranges in Howey being the embodiment of the scheme to sell the groves. If that's the case, how does a corner grocer register an orange with the SEC? Exactly, spot on. All U.S. exchanges immediately suspended XRP trading in fear of SEC reprisal, locking up the tokens of innocent retail holders as the value plummeted by $15 billion. The collateral damage done to these holders that the SEC claimed to be defending was staggering. I organized a class of over 75,000 retail XRP holders and gained amicus curiae status in the case. Our reasons are pretty logical. The vast majority attest they'd never heard of Ripple Labs when they acquired the token for their purposes. These lines of computer code they obtained can't be an investment contract or a common enterprise with a company they'd never heard of, and nothing in the law before or after Howey supports that idea. Judge Annalisa Torres in the Southern District of New York is taking her time with a ruling in the Ripple case because she must understand the stakes, particularly on appeal. The questions to be decided go to the foundations of modern securities law and what assets can and can't be included in it. Torres also knows the current U.S. Supreme Court has been knocking down regulators that overreach the powers Congress specifically granted them. Now, other crypto companies, from Coinbase to Library, started facing similar SEC lawsuits. Gensler's public statements on crypto grew sharper. The larger objectives became clear. He inherited the Ripple case from his predecessor, but he's made its legal theory the centerpiece of an expansion of regulatory power in court, not through rulemaking or legislation. That has drawn Congress's ire. I'm all for clear rules and regulations to protect people, but the SEC is exploiting legal uncertainty about crypto to radically redefine what constitutes an investment contract and a common enterprise in the US. The legal and economic consequences could be enormous, and that will only harm people. That's a fantastic article. And another thing that I think is a major net plus, I mean, this is in Bloomberg law. You're talking about mainstream media here. It's one more way, one more venue to get the message out here. Because I've always said, and I still firmly believe this, anybody that comes in unbiased, you're just a blank template, right? And you just come in with an open mind and you just want to learn the facts. I think almost any human on the entire damn planet is going to come to the same conclusion that we came to. And I admit fully, because I hold XRP, it's my largest cryptocurrency holding. It's my favorite cryptocurrency, so I'm biased, fine. But I'm doing my very best to be always as intellectually honest as possible, and I do believe that. I really genuinely believe that. If somebody comes in, they just want to get to the truth, they're gonna come down on our side. So anyway, great article by Attorney John Deaton there. I'll go ahead and wrap up here so I can take care of my sick dog, though. I better. Oh, what are you doing down there? Oh, poor thing. I know, girl. I know. All right, folks. Oh God. Yeah, she's not feeling well. Oh God. I better get going. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.